right from wrong. It is on this basis that we now proceed to declare what is just, what is unjust, and to distinguish what is right from what is wrong. Mombasa, Muko. JR number 30 and petition number 26 of Mombasa. These two cases have been considered together as they raise identical issues. They both relate to the delimitation of wards in Jomvu and Changamwe constituencies. The petitioners affirm that the Changamwe area comprises of various ethnic groups and clans that identify well with the name of Changamwe. They submit that the name Changamwe originated from the Changamwe, who are the origin and the native inhabitants of Changamwe area. They also aver that they are aggrieved by the alleged failure of the IBC to take into account their views concerning the delimitation of wards in Jomvu and Changamwe constituencies. We have carefully scrutinized the pleadings and submissions filed in these two cases. These issues arising of these cases are whether there were consultations carried out by the IEBC and whether IEBC violated Article 89.5 in the delimitation of Magongo and Miritini County Assembly wards of Jomvu and Changamwe constituencies, respectively. We are not convinced that the mere diversion of a road could inform the decision taken by placing these wards in the affected constituencies. The proposed Changamwe ward has only one sublocation, namely Changamwe sublocation. In our opinion, the petitioners have demonstrated the existence and the essence attached to the name Changamwe. They have also demonstrated that the name has historical and cultural significance, and therefore changing into Magongo without any reasonable basis cannot be entertained. For the reasons, we order as follows. 1. Magongo ward is renamed Changamwe ward and is transferred to Changamwe constituency. Changamwe constituency shall now comprise of the following wards: Changamwe, Potris, Kibevu, Airport, Chani wards with a population of 132,692. 2. Miritini ward to be removed from Changamwe constituency and transferred to Jomvu constituency. Jomvu constituency will now comprise of Jomvu Ku, Miritini, and Mkindani wards with a population of 117,487. 3. We order the maps of Changamwe and Jomvu constituencies in Volume 3 of the IEC final report be and is hereby altered and amended to reflect the above changes and positions. 5. Accordingly, legal notice number 14 of 2012 of 6th March be and is hereby amended to that extent. There shall be no orders as to costs. Kwale County, constitutional petition number 22. This petition concerns the delimitation of Bongwe Kikoweni ward in Lungalunga constituency and the Masambweni constituency. The petitioner's case rests on the fact that the residents expressed the views to the effect that the boundary between Lungalunga and Masambweni constituency river be River Hamisi, and that the 3 sublocations of Kikwede, Funzi, and Shirazi be part of Ramizi ward in Masambweni constituency, rather than the proposed Lungalunga constituency. The petitioners state that River Ramisi is a geographical and historical feature to the 3 sublocations, and delimiting it to Bongwe Kikoneni ward has derived the residents of Funzi, Kikwede, and Shirazi sublocation of the historical identities. We have considered all the issues raised by all the parties, and it is our view the IEBC is mandated by the Constitution to take into account other factors as set out under Article 89.5 in addition
to population quota. It should be borne in mind, as we have reiterated above, that the respondent's mandate must be carried out in full promotion of all the principles and values that underlie the Constitution. In this case, IABC has not provided any specific response to the claims filed by the applicants. Lastly, we consider the effect of granting the prayers by the petitioners in terms of the population in both constituencies. Our analysis does not show any disparity that will lead us to decline the order sought. The population of the three sublocations of Funzi, Kikwende, Shiranzi is 10,744, and the removal from Bongwe, Kikoneni ward will still result with a population of 41,098. We have also noted the removal of the three sublocations will not affect Lunga Lunga constituency population. The population of Ramisi ward will be 38,708 if the three sublocations are transferred to the ward, which is comparable to the population of the other wards in Masambweni constituency. In the circumstances, we allow the application and reverse the IEBC decision in regard to the affected sublocations. We order accordingly, we order and make the following orders as follows: that Funzi, Kikwende, Shirazi sublocations be and are hereby removed from Bongwe, Kikoneni ward in Lunga Lunga constituency and transferred to Ramisi ward of Masambweni constituency. Ramisi ward of Masambweni constituency shall now comprise of the following sublocations: Vijukini, Milalani, Mivomoni, Kikwende, Funzi, and Shirazi, with a population of 38,707. Bongwe, Kikoneni ward of Lunga constituency shall now comprise of Majorani, Mizizima, Shimoni, Wazini sublocations with a population of 41,098. 3. That the maps of Lunga Lunga and Masambweni constituencies of Volume 3 of the IEBC final report be and hereby altered or amended to reflect the above changes and positions. 4. Accordingly, legal notice number 14 of 2012 of 6th March be and is hereby amended to this extent: there shall be no orders as to costs. Kilifi County, petition number 140. This petition concerns the delimitation of Ganze constituency in Kilifi. The petitioners claim that Ganze is the poorest constituency in the country as a result of being marginalized for too long by successive governments, and that education levels are too far low and that there is lack of infrastructural development. They therefore want the following orders: that the number of wards be increased from 4 to 5. We have also considered their grievances against the responses by IEBC. We have reviewed the material before us, and we do not agree with assertions by IEBC that it has no ultimate duty to protect the interests of the marginalized groups. As a state organ, it is bound to observe the provision of the Constitution, including those that the minorities and marginalized, in this case, allege. We are cognizant of the petitioners' grievances about the lack of infrastructure and difficulty in accessing services, but we are convinced this argument is not strong enough to warrant interference with the decision of the IEBC in relation to Ganze constituency. The administrative units, as they currently exist, will be reviewed and streamlined in order to ensure effective delivery of services and the new devolved form of government. We therefore decline to interfere with the decision of IEBC on this ground. We also agree with the contention by IEC that the limitation of few wards does not in any way affect revenue allocation, as this is governed by other provisions in the Constitution and is not affected by the limitation. On the decision to change the name of Ganze ward to Dungicha ward, this is within the mandate given to the respondent under Article 89, Sub-Article 8. We, however, find the reasons by IEBC are not sufficient to warrant a change of name, because there are many other wards, not only in the country, but also in the region, that bear the same name as the constituencies in which they are located. We therefore order as follows. A, that Dungija Ward in Gaze constituency is renamed Ganze Ward, and all other prayers are hereby declined. Legal notice number 14 of 2012 of 6 March be amended to that extent. There shall be no orders as to costs. Petition number 122, Nairobi. This petition concerns the limitation of boundaries of Kilifi North and Kilifi South of Kilifi County. We have considered also their grievances against the issues raised by the respondents, and it's our view that in terms of population quota, the petitioners assert the IEBC disregarded the prevailing population numbers in the location and county assembly wards, that Marareni sublocation should have been delinked from Marareni County Assembly Ward and joined to Sokoni County Assembly Ward, adding a population of 7,300 to Kilifi North constituency, thus bringing it to the population quota. We have considered all the issues, and having considered the pleadings and the material placed before us, we find that IEBC did in fact consider the issues of community interest and geographical features and how they will affect the population of quota of Kilifi North. Changing the boundaries of Kilifi North constituency will have a domino effect and will entail changing the boundaries of all the constituencies of Kilifi County. We do not find the IEBC failed to take into account matters it should have considered or took into account extraneous matters. Therefore, the petition is accordingly dismissed with no orders to costs. Petition number 32 of Mombasa. This relates to Jaribuni County Assembly Ward of Ganze in Kilifi. We have also considered all the issues and noted the petitioner's complaints are based on what they allege to be historical misrepresentation concerning the administrative boundaries of the areas which they occupy, which fall under two different constituencies. We cannot deal with these issues arising from the complaints of the petitioners, since our powers are limited to matters of delimitation carried out by the respondent. The petition is accordingly dismissed with no orders to costs. JR number 27, Mombasa. This application concerns the delimitation of Jibana County Assembly Ward in Rabai and Kalaleni constituency in Kilifi County. We have considered the argument of Mr. Kenga and the pleadings and submissions and filed by the respondent. The IEBC have raised the issue of population quota to justify their decision, but this must be balanced against the consensus presented by the people of the Jibana, represented by the applicants, their community of interest and geographical features. We note that Rabai constituency was created as a result of the split of Kaloleni constituency, and there was no obligation on the part of IEBC in conducting the first review to attain instant demographic equality. For these reasons, we do allow the application to have the 4 sub-locations with the Jibana community to Kalaleni constituency, as it is clear that there will be minorities in both Jibana ward and Rabai constituency. We make the following orders. A, Jibana ward of Rabai constituency is renamed Kambe/Ribe ward. B, Rabai constituency shall comprise of the following county assembly wards: Rabai, Ruruma, Manawesa, Kambe, with a population of 97,185. C, Kaloleni constituency shall comprise of the following county assembly wards: Kaloleni, Marekani, Mwanawinga, Kayafungo, with a population of 155,739. Jibana ward of Rabai constituency shall comprise of the following: Bangani, Charungo, Kikomani, with sublocations with a population of 17,319. Kaloleni ward of Kaloleni constituency shall comprise of Chilulu, Sagwa, Kwale, Yalani, Birini, Visakani, Kinani, Makamboni, Mikirani, and Chalani, with sublocation with a population of 56,026. The maps of Rabai and Kaloleni constituency in volume 3 of the IEBC final report B and is hereby amended to reflect the above changes and position. Accordingly, legal notice number 14 of 2012 B and is hereby amended to this extent. There shall be no orders as to costs. Petition number 116 and 145, Mombasa. These petitions concern the delimitation of Malindi and Magarini constituencies of Kilifi County. We have considered all the arguments presented by the parties together with what has been presented by IEBC in relation to the request to have Sabaki River at Sabaki Bridge to form the border between Malindi and Magarini. We are not satisfied with the argument that was presented to us by the applicants that such a scenario will put a difficulty of transport across the wards because the limitation of electoral boundaries has not served to erect physical barriers across wards or constituencies. We therefore decline to grant the order sought and make no orders as to costs. Tana River, 29. Tana River, petition number 29. The petitioners are residents of Galole constituency in Tana River County. The application is based on the ground that IEBC reduced the 9 civic wards currently existing to proposed 4 county assembly wards. We have also considered all the arguments, and there is no basis for us to allow the application. The petition is dismissed with no orders to costs. Lamu, petition number 28. This petition relates to Lamu East in Lamu County. The petitioners contend the IEBC omitted Mwajambwali sublocation in Bate Island with Lamu. In its review, we have considered all the issues, and our observation has shown that Kizikitini is physically on Vaza Island and should therefore remain in Vaza Island. Ndau and Kiwayu Islands are closer to Kiunga Ward than Vaza Ward. In order to correct this error, we direct that legal notice number 14 of 20 be and is hereby amended. A, that Vaza Ward comprise of Kwatini, Kwatongani, Chunda, Maya Bogi, Siyu, Bate, Kizingitini sublocations with a population of 13524, and B, Kiunga Ward comprise of Rubu, Mokokoni, Ndau, and Kiwayu with a population of 4,265. There shall be no orders as to costs. JR number 32B, Nairobi, which concerns the limitation of Lamu County Assembly. We have considered also the issue, and we find no merit in that application. The same is therefore dismissed with no orders to costs. Petition number 33 of Mombasa. This petition concerns the limitation of county assembly wards in Lamu West of Lamu County. We have considered also all the issues raised, and in the result, the application is dismissed with no orders to costs. Taita Taveta County, JR number 141. The applicants seek orders of certiorari to quash legal notice insofar as it relates to Voi, Wandanyi, Taveta, and Mautete constituencies, and they seek other orders of prohibition and mandamus, and it concerns the size and the area of those 3 constituencies. All the 4 constituencies in Taveta were protected constituencies. We have considered the material placed before us, and we note that all the 4 constituencies of Taita Taveta are protected within the meaning of Section 27 of the 6th schedule. We also note that their boundaries are not in dispute and were not subject to delimitation. It was not within the mandate of IEBC to interfere with the areas of protected constituencies, as they were not available for delimitation. In our analysis of the materials laid before us, we note that there are discrepancies between the figures contained in the IIBRC report, the IEBC revised preliminary report, and the IEBC final report with respect to the 4 subject constituencies. In addition, the IEBC principal reply affidavit in paragraph 53 sets out the areas of protected constituencies, which differ from those stated in legal notice number 14 of 2012 with respect to the 4 subject boundary constituencies. We have calculated the area for Taita Taveta County from the 2009 population and housing census report, and our conclusion is that particulars of the area for Taita Taveta County as contained in legal notice number 14 is the correct one. We have a note that Sava West sublocation, whose population and area are factored in Mata Ward, is not contained in legal notice number 14 of 2012. We also find that the map appearing in volume 3 of the IEBC final report does not reflect Sava West and Indili-Dao sublocations in Mata Wards of Taveta constituencies. We therefore direct as follows: that legal notice number 14 of 2012 be corrected to include Sava West sublocation in Mata County Assembly Ward. The map for Taveta constituency appearing in volume 3 of the IEBC final report be amended to reflect Sava West and Indili-Dao sublocations in Mata Ward. Subject to the affirmation, to the aforesaid, the application is dismissed with no orders to cost. JR number 34. JR number 34. The applicants are dissatisfied with the decision, with the delimitation of Wusi, Kishamba, and Ronge wards of Moitate constituency. We have also considered, and as regards the Wusi, Kishamba, and Ronge wards of Moitate constituency, we find that there is no basis to grant any relief with respect, and we see no basis interrogating this matter further. The application is dismissed. No, this 10 is the next county, is the next,
In all the matters which will have been confirmed in favor of the petitioners and applicants, the order resulting will be that legal notice number 14 of 2012 be and is hereby amended, and the maps be altered and amended, so that that portion of the order will not be repeated in those matters. Judicial review application number 120 of 2012, Nairobi. This application relates to the delimitation of Balambala and Dujis constituencies of Garissa County. The petitioners want the decision to move Alango Arba and Medina wards to Balambala reversed, for Dujis constituency to be renamed Garissa Township, since Dujis sublocation is now in Balambala, and an order be made regarding the legal notice. We have considered the response by the IEBC. We note that the basis of the subdivision of Lagdera and Dujis constituencies to form Balambala and Dadaba constituencies was a carefully negotiated settlement between the clans of Garissa County. We are cognizant of the fact that clan interests form a strong community of interest in Garissa County. The IEBC should have considered the proposal to have Dujis constituency be renamed Garissa Township, since Dujis sublocation is now in Balambala. Retaining the name Dujis for the constituency can be misleading. We therefore allow the applications and order as follows: that Dujis constituency be renamed Garissa Township constituency, that Medina sublocation be and is hereby removed from Sankuri ward in Balambala constituency and transferred to Galbet ward in Dujis constituency. Galbet ward will now comprise of Galbet and Medina sublocations with a population of 43,244. Alango Arba sublocation be and is hereby removed from Sankuri ward in Balambala constituency and transferred to Dertu ward in Dadaab constituency. Dertu ward will now comprise of Alango Arba and Dertu sublocation and will have a population of 15,013. Sankuri ward will now comprise of Balicha, Simbir, Sankuri, Raya, and Atelele sublocations with a population of 10,719. Constitutional Petition number 124 of 2012, Nairobi. The proceedings in this matter relate to the delimitation of Dujis constituency and the proposed Balambala and Lagdera constituencies in Garissa County. We note that the issues raised in this petition are the same as those in Nairobi JR application number 120 of 2012. Our findings and orders therein apply mutatis mutandis to this application. Judicial Review application number 118 of 2012. This application also concerns the delimitation of Balambala and Dujis constituencies, where the applicants seek for Medina sublocation in Balambala and order that Bula ward from Balambala constituency be taken to Dujis. We have considered and addressed our minds to the issues raised by the applicants. We are unable to grant orders sought due to insufficiency of the materials presented. It is not clear to us how a ward is to be created for the Boni community in the absence of sufficient details from the applicants on the exact location of the Boni community and their population. This court is unable to answer and intervene. We analyzed the wards as delimited, taking into account the populations and the geographical locations of the sublocations. Taking all factors into consideration and having examined all the available information, we regret that the rights of the Boni as a minority cannot be enforced through this delimitation. In regard to whether IEBC has mandate to readjust the boundary between Ijara district and Tana River district, the guiding law is the Constitution. Readjustment or delimitation of any other units other than wards and constituencies is not part of the mandate of IEBC. Therefore, IEBC cannot adjust boundaries between Garissa and Tana River counties. Finally, the claims for another additional ward for the Abdallah clan are unsupported for the reasons we have set out. Similarly, the claim for an additional constituency has no legal foundation. We hereby dismiss the application in its entirety. Judicial Review number 119 of 2012. The application concerns the delimitation of Balambala and Dadaab constituencies in Garissa County. Applicants are aggrieved by the decision of making Alango Arba part of Sankuri ward of Balambala constituency. Having considered the arguments made in this application, we note that the issues raised in this petition are the same as those in Nairobi JR application number 120 of 2012, and our findings and orders therein apply mutatis mutandis to this petition. Constitutional Petition number 131 of 2012. This petition concerns Lagdera constituency in Garissa County. The petitioners contend that IEBC did not use the minimum population quota criteria for the Malmin region, and that in merging Malmin and Ilan sublocations is unnecessary because Malmin sublocation already had the required population. They also claim that Rare Kasim subclan, which is a minority subclan, will be disenfranchised. We have considered the arguments presented by the IEBC as well, and we have considered this in the light of what we have stated in the petition number 120 of 2012. The delimitation of constituencies in Garissa County followed a carefully crafted formula agreed upon by the various clans in the county. And following our findings, we are unable to interfere with the decision of IEBC. For the reasons expressed above, the petition is hereby dismissed with no orders as to costs. Judicial Review application number 90 of 2012. Number 98 of 2012. This application relates to Ijara, Fafi, and Dujis constituencies in Garissa County. The applicants contest the decision of IEBC to transfer Hulugo to Ijara while retaining Galamalgala, Bulagolol, Jubis, and Garasueno. They argue that the carving and creation of the wards for the Abdallah community in Ijara, Fafi, and Dujis were unfairly done. We have considered the arguments presented by the interested parties who are opposing the application. We have considered all the documents and materials filed by the applicants, respondents, and interested parties. We find that there is no evidence to demonstrate that IEBC acted contrary to the Constitution and the IEBC Act, more particularly because the constituencies are protected constituencies under the provisions of Section 27 of the 6th Schedule of the Constitution. In the circumstances, we find no basis for granting the orders sought and accordingly dismiss the petition with no orders as to costs. Constitutional petition number 92 of 2012, this relates to Dadaab, Balambala, and Dujis constituencies in Garissa County. The petitioners contend that by placing Alango Arba and Medina in Balambala, the respondent ignored geographical features, means of communication. Having carefully examined all the arguments advanced by the parties, we note that the issues raised in this petition are the same as those in Nairobi JR number 120 of 2012, and our findings and orders therein apply mutatis mutandis to this petition. Wajir County, Constitutional Petition number 97 of 2012. This petition concerns delimitation of Wajir South and partly Elders constituencies. The petitioners in this case seek an order compelling for the number of wards for Wajir South to be increased so as to accommodate Hambalash sublocation on the basis that its population was not reflected in the census. We have considered the arguments raised regarding the 2009 population census. We have also held that an application to review under Article 89 is not a forum for litigating or examining the validity of population census. Regarding the number, we have also considered the arguments relating to the creation of additional constituencies, and we reiterate that we have stated earlier that firstly, there are only 290 constituencies available for delimitation across the country. These constituencies were distributed in a fair manner across the country to give effect to the right of fair representation to every citizen. Secondly, the creation of new constituencies is constrained by provisions of Section 27 of the 6th Schedule. Regarding the issue of retaining the number, we note that the respondent is constitutionally mandated to review the number, names, and boundaries of wards periodically, and unless the petitioner in this case can demonstrate to this court on how the change infringes on their fundamental rights, higher standard than a mere sentimental attachment, we find no reason to intercede in the exercise of the respondent's mandate. As regards the contention that Wajir South is underrepresented, we have considered the population of Wajir South as a whole. Taking the population into account and applying the IEBC formula for allocation of county assembly wards, Wajir North and Wajir West constituencies each received an additional ward. Wajir South covers 21,595.70 kilometers, while Wajir North and Wajir West cover 8,303.80 kilometers and 9,010 kilometers respectively. Wajir South has a population of 130,000, while Wajir West has 91,000. We also note that Wajir West was split into two. Considering all these factors, we are of the view Wajir South is underrepresented and was most deserving of an additional ward to balance representation within the county. We think that IEBC did not take into account relevant guiding factors in order to balance the population and to give effect to the principle of representation. We merge Wagala with Ganyure Ward, Assembly Ward, to create Wagala Ganyure County Assembly Ward in Wajir West, to create a new ward in Wajir South. Gerile, Hambalash, and Salah Umar and Dif sublocations of Wajir South constituency are merged to Dif County Assembly Ward. A new county assembly ward, the Dajabula, shall comprise the Dajabula sublocation. These are the orders that we make. Wajir West constituency shall comprise the following wards: Adem Sajadida, Hadado Atipohol, Arbajan, and Ganyure Wagala. B. Ganyure Wagala County Assembly Ward shall comprise the following sublocation: Bamishe, Ganyure, Bojiheri, Kukukale, and Wagala, with a population of 23,913. Wajir South constituency shall comprise the following county assembly wards: Habaswein, Bename, Lagbogol, South, Ibrahim Ure, Burder, Dif, and Dadajabula. Dif County Assembly Ward shall comprise Gerile Hambalash and Salalma and Dif sublocations with a population of 15,692. Ibrahim Ure County Assembly Ward shall comprise Ulalei, El Adao, Ibrahim Ule, and Handaki sublocations with a population of 19,926. Dadajabule shall comprise Dadajabule sublocation with a population of 8,693. Judicial review application number 101 of 2012. This concerns Wajir South constituency. The petitioner seeks relief in delimitation of Wajir South constituency by creation of 2 extra constituencies on the basis that Wajir South constituency has a population of 130,000 and covers a large land mass. The issues in this petition have been dealt with in petition number 97 of 2012, and we adopt the decision in that case. Judicial review application number 148 of 2012. The applicants filed an application here regarding delimitation of ward and ward boundaries in Wajir East and Wajir South. Applicants are particularly aggrieved by the decision to make Wajir Bor part of Wajir East rather than Wajir South. The applicant's main grievance is based on the allegation that the respondent failed to take into account community of interest. We have considered the arguments that have been presented before us. A scrutiny of the populations of the sub-locations that have been referred to show that there will be no disadvantage suffered if they remain in that part of the constituency. In the circumstances, we dismiss the application with no orders as to costs. Petition number 118 of 2012. This one relates to Wajir North constituency. The petitioners are aggrieved by the decision of the respondent to delimit the boundaries of Batalu County Assembly Ward, placing Buna sublocation in Batalu as opposed to Malka Gufu on grounds that the IEBC ignored the representations and recommendations. It is also their contention that Malka Gufu, like all the other 5 wards, is mostly populated by the Ajuran clan. We have considered the response by IEBC. The interested parties agree with the boundaries as drawn and assert that the Godia are only trying to marginalize the Ajuran. We have noted from the documents before us that the majority of those who presented their views to the respondent are from the Ajuran clan. The petitioner's claim is based on their being a minority. They are therefore required to demonstrate that they are indeed a minority and that their rights have not been taken into account. We find that the petitioner has not demonstrated to this court that the population of the Dogodia clan that reside in Batalu ward, and therefore we are unable to infer that their rights have been violated and that the delimitation would assist in resolving their grievances. We therefore decline to grant the orders sought and make no orders as to costs. Petition number 141 of 2012. The petitioners, this relates to Wajir South. The petitioners pray for a new constituency to be known as Wajir Central constituency, comprising of Kulalei location from Wajir South, El Nur, Wagala, Ganyure, Kukukala, and Bojiheri locations from Wajir West. We have already dealt with the issue of the number of constituencies in the earlier part of the judgment and find no basis to entertain the petitioner's request for an additional constituency. We also find no basis to interfere with the boundaries of the affected constituencies as prayed by the petitioners. On the issue of the constitutionality of the legal report, this court held in petition number 72 of 2010 that IBRC process was in accordance with the law. The question of the validity of the census results and the other issues raised in this petition have been addressed in the earlier part of our judgment, and this claim is therefore without basis and it stands dismissed. Petition number 142B of 2012 this concerns Wajir East constituency. The petitioner's case is that Wajir East constituency is sparsely populated, and coupled with the influx of people to Wajir town because of drought in parts of the region, hence it is within and around Wajir town that the population is high. It is their contention that Wajir town should be the nucleus of any new constituency carved out of existing constituencies in the county. We have considered the pleadings, evidence, and submissions. We note that the substantial arguments in the petition have been dealt with in the first part of this judgment, and we have made our findings on most of the issues. We reiterate the basis for calculating the population in Kenya. Insofar as the petitioner's case proceeds from new or projected census figures, it lacks a firm foundation. We have also considered whether Wajir East should be renamed Wajir Central. The question must be determined in the light of the configuration of constituencies in Wajir County. The constituencies are aligned in a north-south, east-west configuration. We therefore find no basis to interfere with the decision of IEBC in naming the constituency. In the result, the petition is dismissed with no orders to post. Mandera County. The applicants seek, this is a JR review application number 117 of 2012. The applicants seek orders to the effect that Wargadud East, Kurmadao, and Sukela Tifna locations of Mandera County should not be part of Ashabito ward in the new Mandera North constituency, but rather they should be part of Wargadud ward in the new Mandera South constituency. We have considered the application and all the issues raised by the applicants to satisfy ourselves whether the grievances warrant interference with the IEBC finding. Having addressed our minds to all the issues, it is our finding that the application lacks merit. Consequently, the same is dismissed. Judicial review application number 114 and 116. Both of these applications relate to delimitation of wards in Mandera East and Lafay constituencies. We shall determine the two applications, that is JR number 114 and JR number 116 of 2012 together, as they raise similar issues. Basically, what they seek is for reinstatement of current civic wards of Gadudie, Kalalio, Bela, Karau, Garbakole, and Hareri Hosle as county assembly wards within Mandera East constituency. It is also their contention that IEBC did not take into account the fact that the population of Mandera East constituency is 178,831, and were Arabia and Libehia to be removed, the population quota would still be met. It is the applicant's claim that IEBC did not properly address the criteria in Article 89.5 and the principles and values contained in Article 27. They further contend that IEBC failed to take into account the need to alleviate the disadvantages suffered by minority Kona tribes due to past discrimination, thereby breaching their rights. We have evaluated the pleadings on record and submissions filed by both sides. This case is centered on whether the Kona tribes are indeed minorities and whether or not IEBC properly took their interests into account. We note from the affidavits deponed to by the applicants that the Kona tribes are recorded as being freed slaves of the major tribes and that these tribes look down upon them and do not treat them as equals. In fact, in the Mandera district record book that is cited by one applicant, these Kona tribes are sometimes referred to as Adone, a Somali word meaning slave. It is clear that despite the dismissal of the interested parties and the respondents of these claims as attempts to create clan enclaves by Kona tribes, they do not stand on equal footing with the other tribes. We find that the Kona tribes, who form a distinct unit whose interests are peculiar and not taken care of by other larger tribes, have the right to be represented by people belonging to the same social, cultural, and economic context as themselves. In order to give effect to the rights of the minorities in Lafay and Mandera East, we now make the following orders. That Libehia ward in Mandera East constituency Libehia ward in Mandera East constituency be moved to the proposed Lafay constituency to be merged with Sala ward to form the new Libehia County Assembly ward. The new Libehia County Assembly ward shall comprise of Sala, Libehia, Kurader, Gumbisu, Hareri, Haresa sublocations with a total population of 45,377. Lafay constituency shall comprise of Libehia, Fino, Lafay, Warankara, and Alango Goff County Assembly wards with a total population of 149,425. We decline the prayer to move the proposed Arabia ward to Lafay. Consequently, the said ward will remain in Mandera East. That there be created a new ward in Mandera East named Bulampia, comprising Bulampia, Kamor, Bukolo, Barpo, Hareri, Hosley, Bida Kamor, Ele, and Shafei sublocations to provide for the minority corner tribes with a population of 39,537. Further, that there be created a new Neboi ward in Mandera East constituency comprising of Neboi, Bur, Abor Sharif, Bula Haji, Figo sublocations with a population of 15,039. That there be created a new Halalio ward in Mandera East constituency comprising of Halalio, Gududie, Bella, Gingo, Karo, and Garba Kolei sublocations with a population of 11,081. Township ward of Mandera East constituency shall comprise Township, Central, Bulanguvu, Bula Jamuria, Bula Power, and Border Point 1 sublocations with a population of 45,358. Mandera East constituency will now comprise of Arabia, Halalio, Neboi, Township, and Bulampia wards. The population of Mandera East constituency will now be 139,262. Judicial Review Application number 144 of 2012. This concerns Mandera West, Banaisa, Mandera North, and Mandera South constituencies. The applicants contend that the respondent failed to take into account the wishes of the Degodia community to have Mandera North constituency include Malkamari and Guba wards from Banisa constituency, and that the Wargadu division proposed for Mandera North constituency be shifted to Mandera South constituency. We have evaluated the facts and evidence before us, and we conclude that the petitioners have not made out a case to warrant the interference by this court of the IEBC decision. The application is therefore dismissed with no orders as to cost.
We now move on to Marsabit County. We are at page 177 of 334. Marsabit County, Judicial Review number 121 of 2012, Saku constituency. The applicants are opposed to the IBC action relating to Leai sublocation. They argue that there are 364 Kenyans of Reniled tribe living in Leai sublocation will be marginalized by the dominant Borana communities in the ward. We have considered the material before us, and in our view, the population of applicants is too small to enable the IBC to take into account their interests in delimiting a ward. In the circumstances, the application is dismissed with no order as to costs. Constitutional petition number 148 of 2012, that is number 32. The petitioners seek to limit North Hor constituency to create two constituencies to enhance equitable representation and representation of minority groups. We have considered the matter, and we note that North Hor has a population of 75,106, and hence it could not be considered for subdivision as a protected constituency under the provisions of the 6th schedule. We also do not find any merit in the request for additional wards, as North Hor has 5 county assembly wards, which is the optimum number allocated to each constituency. According to the formula adopted by the IEBC for allocation of county assembly wards, North Horr was entitled to 3 wards but was awarded 5, taking into account its sparse population and large area. We therefore conclude that there is no justification for this court to interfere with the IEBC decision in this respect, and the application is dismissed with no order as to costs. Isiolo County, county number 11 in the Constitution. The proceedings in this matter, Judicial Review Application number 109 of 2012, Nairobi. The proceedings relate to the delimitation of the boundary between Isiolo and Garissa County. We have considered the material before us, and the applicant appears to contest the location of the boundary between Isiolo County and Garissa County. This is not a matter within the mandate of the IEBC to consider. Furthermore, we were not furnished with any evidence to enable us determine whether the IEBC had exceeded in mandate by interfering with the county boundaries in a manner that would entitle us to interfere with the decision. In the circumstances, the application is dismissed with no order as to costs. We go to county number 12, Meru County, constitutional petition number 135 of 2012, and it relates to the delimitation of Kibirishia ward in Central Imenti Discount constituency of Meru counties, where the petitioner aggrieved by the manner in which the respondent delimited Kibirishia ward, Central Imenti, and Buri constituencies in Meru County. We have considered the arguments and the applicable law, and we find the petitioner's claim regarding the communication barriers to be valid. We know that the representation made by the residents of the area, including a memorandum by the residents of Kibirishia ward to the respondent, proposed that Kibirishia be made part of Buri. We also know that the IEBC report showed Kibirishia ward as being part of Buri constituency. Though the IEBC was not bound by this report, it was not justified by reason for it has not justified the reason for departing from it, particularly given that the populations of the two constituencies are balanced. We also take into account the geographical features and the means of communication, and in particular the existent Mount Kenya forest as a barrier between Kibirishia ward and Central Imenti constituency. We therefore allow the petitioner and make the following orders. 10A, Kibirishia ward shall be transferred to Buri constituency. Central Imenti shall consist of Abogodugushi West, Abogodugushi Central, Mwangadia, and Kiangu with a county assembly wards with a total of 116,918. Buri constituency shall be composed of Tidmao, Kisima, Kiurua Nari, Ruiru Rera, and Kibirishia county assembly wards with a population of 134,653, and consequential orders. Judicial Review number 10 of 2012 filed in Meru. This judgment concerns an application lodged by the residents of Igoki in South Imenti constituency, and it concerns the delimitation of Abogeta West and Abogeta East wards. We have considered the matter, and we have noted that the application concerns the minority status of the Igoki community. However, the applicant has not demonstrated in fact that it is a minority or that its population is such that it can be taken into account in delimiting the wards to promote their interests to prevent marginalization. The evidence suggests that the Igoki community is spread across the two wards, and their interests would be difficult to define and take care of by a process of delimitation of county assembly wards. We therefore find the application lacks merit and is dismissed with no order as to costs. Constitutional petition number 6 of 2012 filed in Nairobi. This petition concerns the delimitation of county assembly wards in Igembe South constituency of Meru County. The petitioners in this case comprise residents on leaders of Amaku and Antubwete and Joune sublocations of Kiengu locations who have moved this court for orders of declaration. They base their claim on the fact that the residents of Amaku and Antubwete and Joune sublocations have traditionally had close cultural, social, economic, and political ties with the rest of Kiengu location. They further argue that they will be form a minority within the proposed Igembe South constituency, and more particularly the proposed Maua ward, which is an urban ward. We have considered all the evidence and Considering all the facts and evidence by both parties, we know that the people of Amako and Antubwete share strong economic, social and cultural links with the people of Igembe Eastward in Igembe Central constituency. We note that this issue was noted in the parliamentary report on the IBC revised preliminary report, which, based on representations made, suggested that IBC should consider the delimitation of boundaries in Igembe Central and Igembe South constituencies in line with the geographical features and community of interest in that region. We have also considered that the geographical features, particularly the position of Givetu Hills in the area, were an important factor for consideration apart from the population quota upon which the IEBC placed undue emphasis. We also note that the delimitation of the two sublocations to Igembe affects the contiguity of Igembe East Ward and the rest of the constituency. The population of Maua Ward, after removing the two sublocations, would be 22,617, and that of Igembe Central will be 193,392 after adding the two sublocations. The reasons advanced by IBC for delimiting the two sublocations was not justified, as the two population figures are within the permitted deviations. In the circumstances, we direct as follows: A, Amaku and Antubwete Njoune sublocations be moved from Maua Ward to Igembe South constituency, of Igembe South constituency to Igembe East Ward in Igembe Central constituency. Maua Ward of Igembe South shall comprise Kithaine, Kathima, Ankurani, Amwanthi, Kaibu, and Gature sublocations with a population of 22,617. Igembe East Ward of Igembe Central constituency shall now comprise Kanjo, Kitheo, Thampira, Nthare, Kalingene, Andiala, Kaurine, Amako, and Antubwete Njoune sublocations with a total population of 44,491. The population of Igembe Central now will be 193,392, and that of Igembe South will be 134,550. We now go to the county number 13, Tharaka Nithi County, and they have filed judicial review application number 100 of 2012 of Embu, and this concerns the delimitation of Kithino, Tunyai, Murinda, Karocho, Turima, Kathura, Tumbura, Makodhima, Kirundi, Thiti, Ntoroni sublocations in Tharaka constituency of Tharaka Nithi County and former Nithi constituency, the proposed Mara constituency, and Igoji westward of Imenti South constituency in Meru County. We have considered the material and evidence before us, and we find that a valid determination of was done on the basis of existing sublocations which had already been determined and for which coordinates are available from the Director of Survey. The IBC, in conducting the delimitation, is required to use sublocations as units for delimitation, and Meru National Park was an existing sublocation in Igembe Central constituency. IEBC has no mandate to change existing administrative boundaries. Furthermore, the petitioners have not shown within which administrative unit in Tharaka Nithi County the park was and is situated. We are therefore unable to make any determination as to whether the Meru National Park was situated in Tharaka Nithi County and whether the county boundary between Tharaka Nithi and Meru County has been changed. We have also examined the 2009 population census report, the IBRC report, and the preliminary report of the IEBC, the parliamentary report, the revised preliminary report of the IEBC, and the final report of the IBC, from which we note that Machabini sublocation does not exist. In the circumstances, the petition is dismissed with no order as to costs. County number 14, Embu County, judicial review application number 55 of 2012 and 120 of 2012 concern the decision of the IBC regarding Bere North constituency, and they shall be dealt together, and it is based on the petitioners and applicants' cases that the Mbere people have long time been marginalized in all sectors, including education, health, and infrastructural development, and they seek the wards to be balanced in an equitable manner. They have urged this court to split Evurore County Assembly Ward into two. We have assessed the material before us, and we note that we found that there is no basis for grant of this order, as the maximum number of wards in the country is 1450, and all of which have been allocated in accordance with the formula provided, and that Embu County was entitled to 20 county assembly wards. These wards were distributed amongst the constituencies in Embu County in accordance with the respective populations. Mbeere North, being a protected constituency, had the least population and is entitled to 3 wards. In the circumstances, we are unable to order the creation of an additional ward or to split a rural ward in Mbeere constituency as proposed. In the result, the application and the petition are both dismissed with no orders to cost. Petition number 136 of 2012 concerns delimitation of Manyata constituency in Embu County. The crux of the petition is that the IEBC used, adopted, and replicated the Ligala report, yet it had the mandate to carry out its own delimitation. We have dealt with the issues concerning the constitutionality of the first review. The applicants who claim that they are a member of the Gaturi Association or the residents of Gaturi area have not shown the basis on which a new constituency can be provided. In any case, the maximum number of constituencies is provided for in the Constitution, and we cannot increase the number. Further, we appreciate the IEBC was bound by decisions and findings of the IIBRC as regards the establishment of new constituencies under Section 2 of the 5th Schedule. In our view, we do not find any merit in this petition, and the same is dismissed with no order as to costs. County number 15, Kitui County, Judicial Review Application number 129 of 2012, filed in Nairobi, and this relates to Mwingi East and Mwingi West constituency. The applicants are seeking the change of name of the proposed Mwingi East constituency to be renamed Mwingi Central. They are also seeking that the name Maithiakani in Central County Assembly Ward in Mwingi West constituency be replaced with the name Mathiakani, and they are seeking removal of Central Ward except Kavuvuani sublocation from Mwingi West constituency to Mwingi East, and Kavuvuani sublocation moved to Kiethani Ward in Mwingi West. The applicants contend that the respondents' decision to split Mwingi town between the 2 constituency and 2 county wards is unpopular in Mwingi, since the residents of Mwingi will now be served by 2 different members of parliament and the ward representative, depending on which side of the road one is on. Since IEBC identified the main Mwingi-Garissa road as a boundary ward, the applicants have vowed that their grievances were not taken into consideration. The IEBC disputes this and says that they took into account the typography and geography of the area. We have considered the matter in regard to the proposed name change of the sublocation. Unfortunately, the IEBC has no mandate to change the names of sublocations. We know that the name Maithiakani appears in the 2009 census report as the name of the sublocation in Kanzunzu location of Mwingi West constituency. The circumstances, we are unable to intervene, and the applicants are urged to approach the relevant authorities to change the name of that sublocation. The second issue is that of renaming Mwingi East to Mwingi Central, and whether the town of Mwingi should be in one constituency as opposed to being divided into 2. The IEBC misunderstood the submission by the applicants. What the applicants sought was not the creation of a new constituency, but rather to merge the town in one constituency. There is a community of interest in an urban area, and it was incumbent upon the IEBC to interrogate this factor and weigh it against the population factor. Taking into account the applicants' and inhabitants' wishes would not affect the populations in either constituency or ward. In the circumstances, we direct as follows: Kivuvuani sublocation of the proposed central ward of Mwingi West to be moved to Kiomo Kiethani ward of Mwenge West constituency. Kiomo Kiethani ward will now comprise Kavuvuani, Mbondoni, Kiomo Kiethani, Kairungu, Karura, and Wakithuki, with a total population of 25,897. Mwingi West will now have a total population of 117,723. Mwingi East constituency will be now renamed Mwingi Central constituency, and the central ward in Mwingi West constituency will be moved to Mwingi East, now renamed Mwingi Central constituency, which shall comprise Mwingi, Kalisasi, Maithiakani, and Kanzunzu sublocations with a total of 18,846. Mwingi East constituency is now renamed Mwingi Central and will comprise Waita, Kivou, Mu, Nu, Nguni, and Central wards with a total population of 127,258. Judicial Review number 108 of 2012, Nairobi. The applicants sought to move the court for orders relating to the limitation of Kitui Rural and Kitui Central constituencies regarding various county assembly wards. The applicants contend that the respondent acted in total disregard of the proposals of the Yatta people not to be included with the wards of Kisasi, Katulani, and Bitini, with whom they had no historical or cultural historical ties with. They contend that the population of Kisasi and Bitini share no cultural ties with the Yatta people, whose origin is in Machakos. That by including Kisasi, Bitini, Katulesi wards, the IEBC disregarded the community of interest and the historical and cultural ties of the affected wards, which were hived off from Kitui ward. The applicants further argue that there is no means of communication of infrastructure linking the inhabitants of Kwavonza, and that is the lower part of Yatta, with Kisasi and Bitini, and that taking Kisasi from Kitui Central and making it part of Kitui Rural constituency is inconvenient to the Kisasi people due to means of communication. On the other hand, IBC argued that it contrary to the applicant's assertion, the Commission used population quota as the primary consideration. We have considered the material before us. Kitui Rural constituency was split from Kitui Central constituency. The distribution of the population between the constituencies was an important factor for consideration. The removal of Kisasi and Bitini wards from Kitui Rural constituency, as proposed by the applicants, will result in an unviable constituency. The combined population of the two subject wards is 51,617, while the total population of the proposed Kitui Rural is 104,443. The removal of the two wards could negate the intention of the inhabitants of Kitui County to have an additional constituency. Considerations of community of interest, historical and cultural ties in this instance cannot override the population considerations. In the circumstances, the application is dismissed. Constitutional petition number 114 of 2012, Nairobi. These proceedings in this matter relate to the delimitation of Mwingi North and Mwingi South and the proposed Mwingi North, Mwingi East and Mwingi West constituencies. The petitioners seek entirely that the boundaries of Mwingi West and East be reviewed in carving Mwingi Central out of the existing Mwingi North and South in line with the legal report and IBC preliminary report. We have considered the evidence and in view of our judgment in JR 129 of 2012, which we fully adopt, we find no reason to accede to the petitioner's orders and the application is dismissed. Constitutional petition number 117 of 2012, the petitioners have moved the court alleging that the action of moving Katulani, Kwamuli, Kathunga and Itoleka sublocations to Kitui Central constituency and the moving of Kwavonza Yatta to Kitui Rural constituency was in breach of their rights. We have considered the issues in relating to Kitui Rural and Kitui Central constituency, and in line with our judgment in JR 108 of 2012, we dismiss the petition in its entirety. We now come to county number 17, Makueni County, constitutional petition number 133 of 2012. The petitioners are residents of Kinyambu sublocations in Kikumbulu South Ward in Kibwezi and of Mikuyuni sublocation in Thange Ward in Kibwezi East constituencies. They allege that the boundaries of Kikumbulu South and Thange wards have been demarcated by IBC without considering their views and given by the residents. IBC opposes the petition, stating that the limitation was guided by the need for Kibwezi East and Kibwezi West to each host district headquarters, namely Makindo and Kibwezi, both in Mikuyuni sublocation, as a means of increasing access to people's services. Having considered the arguments from both parties, we know that the IPC took into account extraneous factors that are not included in the criteria in 89.5 to disadvantage the valid factors of geographical and community of interest. The district headquarters, no access to services are not amongst the considerations that were required, but instead that of fair representation and equality of votes. We find that the applicants have demonstrated both geographical factors and a community of interest that ought to have been taken into account by the IBC, and that the populations of Kikumbulu South and Thange were well within the population margins if the two sublocations are moved as prayed by the applicants. We accordingly order as follows: that Kinyambu sublocation in Kikumbulu South Ward in Kibwezi West constituency shall be transferred to Thange Ward in Kibwezi East Thange ward will now comprise Utithi, Thange, and part of Chulu National Park and Kinyambu sub-locations, and will have a population of 32, 130. Kibwezi East will now have a population of 132, 196. Mikuyuni sub-location in Thange ward in Kibwezi East will now be moved to Kikumbulu South ward in Kibwezi West. Kikumbulu South ward will now comprise Bunzao, Kalungu, Mikuyuni, and Gandani, which will have a population of 25,892. Kibwezi West will now have a population of 116,508. Number 45, judicial review application number 110 of 2012 filed in Nairobi, and this concerns delimitation of county assembly wards of Ngu Masumba, Embali Mulala, Zui Kaleli Kalamba, and Bitini wards in Makueni constituency, where the applicants seek to quash the inclusion of those wards in Makueni County, and the IBC opposes this and said it has proposed that part of Makueni County and part of Kibwezi County be hived off to create a new constituency to be known as Constituency West, but the residents opposed this request. And having considered the pleadings and submissions of all parties, we note that the population of Makueni is 243,219. The mandate of the IBC in resolving the issues arising out of the first review was to address the population of the constituency in order to affect the principle of fair and effective representation. The population of Kibwezi East is 132,196, Kibwezi West 116,508, Kaiti 120, 116, Kilome 87, 864, Mbooni 184, 624 constituencies in Makueni County, when compared with that of Makueni constituency, demonstrates that the people of Makueni are underrepresented. The populations of Kibwezi East constituency stated in the foregoing reflect our decision in Nairobi, petition number 133 of 2012. We have emphasized the importance of effective representation, and have noted that the applicants' prayers are also similar to the proposals made by the Legale report and the ABC preliminary reports. We have also noted that the public consultations degenerated into violence, and the IBC has admitted that it was unable to get the views of the public. This does not discharge the IBC from its constitutional duty to ensure effective representation of all the citizens of Makueni constituency. It has the full mandate under the provisions of IFC Act, Section 2 of the 5th Schedule, to redistribute such wards and administrative unit as may be appropriate to address the issue of population quota in order to meet the constitutional objective. In order to remedy this situation, and taking into account the submissions and the aforesaid reports, we think a fair and objective representation will be met by moving Emali Mulala and Ngu Masumba ward of Makueni constituency to Kibwezi West in order to reduce the population of Makueni constituency. Taken as a whole, the population of the constituency in Makueni County will be more balanced. We have also considered that the residents of Emali Mulala and Ngu Masumba will still be retained in their respective wards. The redistribution of the said wards will reduce the burden of representation in Makueni constituency. We have also taken into account the fact that the two wards are contiguous to Kibwezi West constituency. The resultant effect of the redistribution is the promotion of fair and effective representation of constituents of both constituencies, which is the primary goal of delimitation. We therefore order as follows: Emali Mulala and Ngu Masumba wards in Makueni will be moved to Kibwezi West. Makueni constituency will now comprise Bitini, Nzao, Kileli, Kalamba, Wote, Muvao, Kikumini, Kathonzweni, Mavindini, and Kitise Kathuki wards with a population of 193,798. Kibwezi West constituency will now comprise Emali Mulala, Ngu Masumba, Makindu, Ngumo, Kikulumbu North, and Kikumbulu South wards with a total population of 165,929. And finally, in Makueni, this 128 relates to 128 of 2012 relates to Makueni constituency. The petition has moved this court alleging that Makueni constituency was unfairly treated given its population. We have dealt with this issue in the preceding judgment, and in view of the orders in JR 110/2012, we need not proceed further with the analysis, and that judgment applies to the case.
County number 20, Kirinyaga County, Judicial Review Application number 12 of 2012, Embu. The proceedings in this matter relate to the delimitation of Mukure Ward and Muura Ward in Ndia constituency of Kirinyaga district. The application is based on grounds that the IEBC ignored the views of the people of Ndia constituency in regard to the delimitation exercise in that constituency. The petitioners asserted that the application, contrary to their popular views, Gitaku and the Kianjangu sublocations have now been moved to Mukure Ward, and that Maitharui and the Kithumbu sublocations have been moved to Kiine Ward. We have considered the application and all the material before us, and note that legal notice number 14 of 2012 describes the wards correctly, and there is no reason for us to intervene, save that the map in volume 3 of the IEBC final report should be corrected to accord with legal notice number 14 of 2012 with regard to the identification of wards in Ndia constituency. In delimiting Muthithi ward to Mwea constituency, we also note that the IEBC took into account the views of the residents of Ndia and that Muthithi ward be part of Mwea constituency. The application succeeds only to the extent that we order that the map of the proposed Ndia constituency in volume 3 of the IEBC final report be corrected to accord with the legal notice number 14 of 2012 with respect to the wards comprising Ndia constituency. Judicial review number 124 of 2012, Embu. This application relates to Ndia and Mwea constituencies in Kirinyaga County. The applicants in this case allege that Ndia constituency was given only 3 wards, namely Mukore, Kiine, and Akariti, contrary to the wishes of the Kirinyaga people made during public fora and public memoranda given to the IEBC during public hearings. It's their plea that an extra ward be created to create four county assembly wards as expressed during public presentations and the parliamentary committee, namely Kariti, Mwerua, Kiine, and Mukure. The application has been opposed. We have considered the materials before us in this matter and concluded that IEBC was legally bound to use the enumerated census results and not projected figures. We note that the enumerated population of Mwea is 195,22. This is above the population quota limits for constituencies. However, as we have stressed earlier in our judgment, the delimitation of constituencies must be looked at in full light of certain other factors, including the maximum constitutional limit of number of constituencies in the country and the constitutional provisions on progressively working towards the population quota. In the circumstances, this court cannot and finds no reason to interfere with the delimitation of Mwea constituency, and the application is dismissed with no orders to cause. Judicial review application number 125 of 2012. This is Murang'a County. These proceedings arise from the delimitation of wards in Mathioya constituency. The applicants herein allege that the IEBC disregarded or ignored their views and that it failed to take into account the criteria set in the Constitution for delimiting wards in this constituency. It is also their case that the IIBRC, in its report, had proposed the creation of wards in Mathioya constituency, which included a ward by the name Njumbi. The IEBC delimited the wards into Kiiru, Gituki, and Kamacharia and transferred Gacharageini, Gagongo, Kiamuturi, Gatunguru, Nyakianga, and Agikoe sublocations from Njumbi ward as proposed in the legal report to Kiiru and Gituki County Assembly wards. We have considered the facts in this case and are of the view that the applicant's case proceeds from a misconception. The IIBRC recommended that the wards for purposes of the Constitution be the civic wards created under the Local Government Act. Njumbi was a civic ward under the Local Government Act. However, after consideration by the IEBC, Mathioya, which is a protected constituency, was allocated 3 county assembly wards, namely Kiiru, Kamachari, and Gatugi, which were delimited accordingly. As there is no complaint about the manner in which the county assembly wards were delimited, the application is hereby dismissed with no orders to cause. Kiambu County, judicial review application number 99 of 2012. The applicants seek orders of judicial review against the respondent in regard to the delimitation of wards within Gatundu North constituency. The applicants allege that IEBC removed Ngedu and Angorongo locations from Chania Ward, removed Igegania sublocation from Mangu Ward to Chania Ward, and took Ndiko sublocation to Gitwamba ward to their detriment. IEBC has opposed that application and submitted that the process of delimitation was carried out in a fair and transparent manner. The applicants, in our view, have not provided any evidence to demonstrate that the IEBC abused its powers. We therefore agree with the IEBC that it complied with the relevant provisions of the Constitution and the necessary statutory benchmarks as it was obliged to observe. The application is therefore dismissed with no orders to cause. Constitutional petition number 126 of 2012, Nairobi. In this petition, the petitioners are complaining against the IEBC's decision delimiting the proposed Kiambaa and the Kiambu constituencies. The petitioners contend that the IEBC disregarded the Parliamentary Justice and Legal Affairs Committee's proposals and ignored the views of the public, and that it also failed to take into account and comply with the provisions of Article 89(5). We have considered the arguments put forward by both the petitioners and the respondents in this matter, and we are satisfied that there was consultation with the interested parties and that the IEBC considered all the relevant material in delimiting the two constituencies. Kiambaa and Kiambu and Kiambaa are delimited from Kiambu constituency, and it was necessary, in our view, to balance the populations of the two constituencies. We have considered the applicants' proposals, and by removing Kanunga and Ngengu sublocations from Dumberi ward, would leave the latter ward with a population of 11,958, which is well below the county assembly ward population quota. As regards Mahindi sublocation, we found no justification for moving to Kihara ward. In the circumstances, there is no merit in this petition as far as we are concerned, and the same is dismissed with no order as to costs. County number 23.
We want to take a health break for 10 minutes. Is it okay? Is it okay? Okay, so let's reconverge at 3 for 10 minutes.